Hey, so we are on Chapter 7. Chapter 7 talks about compulsory self-incrimination, meaning the Constitution protects us from um, government compelling us to speak out against ourselves. And so this one chapter addresses specifically the Fifth Amendment. So the first thing that you should notice about this chapter or about the Fifth Amendment, it talks about compelled speech. So if you think about self-incriminating evidence, there are lots of different ways we can incriminate ourselves through physical evidence. The Fifth Amendment does not protect us from being exposed to criminal liability because of physical evidence. So we're only talking about compelled speech. The Fifth Amendment says that you have a right to remain silent during any custodial interrogation, during trial, during any questioning, and you have the right not to take the stand at a trial. So when you think about your right against self-incrimination, it doesn't just apply when you're involved with law enforcement. It involves anytime you are questioned by any government agency, whether it's the post office, any other government agency. So, but again, the focus is on speech, not on other types of physical evidence. All right, so the Fifth Amendment addresses compelled speech during trial. As a defendant, you cannot be ordered to the stand. You cannot, and that concept goes to several extremes. It isn't just that you can't be ordered to the stand. It is the court cannot comment to the jury that you're not taking the stand. The prosecutor cannot at any time comment in any way on the fact that you're not taking the stand, that you didn't take the stand. They cannot be theatrical and stand up and call the defendant to the stand, only to have the court remind the prosecutor that that's not allowed. If a prosecutor was to stand up and call the defendant to the stand, the court would order a mistrial, and the prosecutor would be severely chastised, if not fined, and they would be reported to the state bar. So it's a serious offense for any prosecutor to even play games with the idea of ordering the defendant to the stand. And that would include during closing arguments. The prosecutor cannot, during closing arguments, talk about why the defendant didn't take the stand and what would happen if the defendant had taken the stand. And we would know, like, for instance, you could comment if you were allowed. The prosecutor could say things like, well, ladies and gentlemen of the jury, if the defendant had taken the stand, we would know what happened that day, but they refused to take the stand. And why are they doing that other than the fact that they're guilty? So that type of comment or statements are not allowed by any stretch of the imagination. Now, the defendant can't take the stand, but they can, again, participate in assisting or when it comes to physical evidence. So the prosecutor can ask the court, Judge, I have a shirt. I want the defendant to try on this shirt. I want the defendant to put on a hat. If those things were relevant to the case, the prosecutor would have to ask. The correct way to do this in the real world would be the prosecutor would go to the judge and to the defense attorney prior to the jury, maybe even prior to the selection of the jury, and say, Judge, during the trial, my intent is to have the defendant try on a hat. And that would give the defense attorney a chance to object, and it would give the court a chance to evaluate the request and then make a decision. If the defendant's body or physical features are in any way relevant, the prosecutor can ask the court to order the defendant to stand up. For instance, let's say the defendant is exceptionally tall, or the victim identifies the defendant as being exceptionally short, or limps on one leg. Whatever physical aspect of the defendant that the victim or other witnesses describe, the prosecutor can ask the court to um, uh, have the defendant stand or in some way show the jury what the specific issue is. Like, for instance, if it's a tattoo, I did a trial where a woman was raped. She didn't know the defendant, but she did know when he was raping her, she saw a bulldog tattoo on his chest. And so I had the defendant stand and expose his chest in a respectful way, expose his chest so that the jury could see that the defendant that was being charged had a tattoo on his chest, which is a relevant piece of information for the jury to consider when deciding innocence or guilt. They can even ask the defendant to read documents. Not that the documents themselves would have any relevance, the words in the documents, but it may be to hear the defendant's voice. For instance, if the defendant or the person that committed the crime, they have a recording of the person's voice, then the jury would have a right to hear the recording and hear the defendant and how the defendant sounds so that they can judge whether or not the person on the tape is the defendant that's in front of them. So a person is protected under the Fifth Amendment at any government hearing where he or she is exposed to possible criminal liability. But the protection goes towards statements or speech. And they can exercise their Fifth Amendment right at any administrative hearing. So you'll see oftentimes in congressional hearings where somebody's been called to Washington, D.C. to talk to the Senate or to Congress, and they will assert their Fifth Amendment right. That is part of our Constitution, and that's part of the protections that you and I have. Prior statements, prior recordings, prior documents with any type of statement is not protected. The Fifth Amendment's very specific. It talks about compelled speech. So prior documents, as long as they were not generated by coercion by the government, through coercion, those would be admissible. So prior tax returns, for instance, prior letters that you wrote, or text messages or emails that were sent, those are admissible because they were not generated or created by the government forcing somebody to make a statement. And historically, this comes from England, King George, where they would, it was very common for them to force someone to make a statement because they believed the defendant was guilty, and then they would simply needed them to make a statement so that they could feel good about their prosecution. And they would force them either through threats of violence or actual violence to make a statement. So our founding fathers put specifically in the Constitution that you could not compel, or the government cannot compel someone to make a statement. So the prosecutor cannot comment to the jury, as I've already talked about, on the defendant's assertion of his or her Fifth Amendment rights. So that means at any time during any type of motions, or anytime they're in front of the jury, the prosecutor cannot talk about the defendant not taking the stand. And the way the court generally handles this is the court will, at the very beginning of the trial, ask, and this is before the jury is selected, or even before the jury is brought up into the courtroom, the court will ask the defense, does your client plan on testifying? And the most common response, probably 99% of the time, is the defense attorney will say, Your Honor, we're still discussing that issue. So they don't really give you much hint or commitment either way. Then during the course of trial, at some point is going to be that time when, if the defendant is going to testify, that court needs to know. So again, outside the presence of the jury, the court will address the defendant and ask, will your client take the stand? And if the defendant does not want to take the stand, then at that time, the defense attorney will say, Your Honor, my client's chosen not to take the stand. Something that's really important is that the decision to testify at trial is solely on the defendant. In other words, the defense attorney controls a lot of what goes on in the courtroom. They determine what witnesses will testify. The defense attorney will determine the questions that need to be asked, etc. They do that with the help of the defendant, but ultimately it's the defense attorney's decision, and they have the right to make the final decision. But when it comes to a defendant testifying, the defendant has the sole right to make that decision. What you're going to see in a courtroom is that at that point in time, outside the presence of the jury, if the defendant decides to take the stand, then you're going to hear a defense attorney stand up and give this long speech about how they talk to their client, inform their client of their rights, admonish the client that that would not be in their best interest to testify. And this is basically a CYA speech by the defendant, by the defense attorney, so that the record's very clear that the defense attorney did their job and that the defendant, even though they've been advised not to take the stand, they have unfortunately chosen to go forward. All right, so we have, when it comes to taking the stand, there are two types of immunity. So you hear oftentimes that the prosecutor will offer, or somebody will be asking for immunity. So there's two types of immunity. There's absolute immunity and use immunity. Absolute immunity means that the individual who's going to take the stand, no matter what they say on the stand, it cannot be used against them. Their statements at trial cannot be used against them in any other future proceedings. And it's a blanket protection. So if they're helping out a prosecutor on a case of drug case, and during their testimony they say, yeah, and we killed so and so to steal his drugs, they are protected from the statements that they were involved in a murder. Those statements at trial are protected, meaning they cannot be used against them in any future hearings. Most of the time, prosecutors will not offer absolute immunity. And by the way, it's the prosecutor that has the sole right to offer immunity. Defense attorney cannot offer immunity, and the court cannot offer immunity. The court must agree to it, but they do not have the power to offer immunity. It's only the prosecutor. Use immunity is a little different. Use immunity says that you can take the stand and you are protected as long as you stay on subject. So if this is a drug case, as long as you talk about the drug case, you're protected. But if you start to admit other crimes unrelated to the drug case, in other words, if you say, oh, by the way, we killed somebody so we could steal their drugs, you're not protected. And so the prosecutor can, in the future, use that statement that, yes, you killed somebody in order to steal drugs. So that's the difference. Absolute immunity is this blanket, no matter what you say is protected. And then use immunity is not protected. You're not protected for anything you say outside of the area that's being questioned. Okay, I'm running out of time. We're going to go on to a second part of this lecture. The second part, I'm pretty sure, is going to be much shorter, but I'm going to stop right here because the clock is telling me that we're out of time.